organizers, director and my colleagues are delighted to see this large gathering on a Monday morning. This is exceptional. Again, thank you for joining us, and we are equally privileged and grateful to have three distinguished guests who doesn't need any introduction. Dr. Anand Nageshwar, Chief Economic Advisor, Government of India, Sri Ravi Chairperson at IBBI, and Sri Siddharth Sharma, Group General Counsel, Dallas. Thank you. We really value your presence. When we planned this workshop, we were expecting a small crowd, to be frank. We were hoping around 10 to 12 papers to be presented. But the response we got for paper, that means we got close to more than 90 abstracts, high quality abstracts. We chose 50. Finally, we had decided on 20 good papers. A lot of papers will take. Sorry for that. The reason we had to reject so many papers is to bring diversity of thoughts and ideas within each session. These 20 papers represent various disciplines covering law, finance, economics, management, behavior, and so on, representing all diverse industries, experts, scholars, government. This interest in research is again truly remarkable, and I would really credit IBBI for engaging with academic institutions like us for many years. So please do continue to engage. The purpose of this workshop is to cross-pollinate ideas across all disciplines. So we hope we'll have a good time over the next 2 days, and I would really encourage you to talk to each other, left and right, back and front, and collaborate. We don't believe in hierarchy in this institution. So please reach out to anyone and everyone, engage and collaborate. And IIMA welcomes any good research ideas to develop a good and comprehensive insolvency research ecosystem. We are open for that. With this short introduction, I request Director, Professor Prospect, to give showcase to our guests. Thank you. Now I request Professor Chairperson of Mishra Center, to say a few words. Mishra Center is supporting this conference along with IBBI.
So, good morning everyone. Once again, a warm welcome to all of you. The Mishra Center for Financial Markets and Economy at IIMA is privileged to co-organize this workshop. I would like to thank Sri Ravi and the Insolvency and Bankruptcy Board of India for their support for this workshop. Insolvency and bankruptcy is a key focus area of the Mishra Center at IIMA. The center has actively contributed to research, workshops and conferences in this area. Professor L.P. Rammohan and Professor Balagopal Gopalakrishnan have been spearheading research in the area of insolvency and bankruptcy and have been making concerted efforts to create an ecosystem for academic work in insolvency. This workshop is one step in this direction. In this context, let me take the opportunity to congratulate Professor Rammohan for being appointed as a part-time member of the Insolvency and Bankruptcy Board of India. Let's give a round of applause. Finally, I would like to thank our director, Professor Bhaskar, who has been very supportive of Mishra Center and particularly towards our efforts to contribute to research and practice in the area of insolvency. Wishing all of you all the very best for a productive and enriching 2-day workshop. Thank you.
Thank you, Sanket. Now we have the lighting of the lamps. Thank you. Requesting Professor Pastor, Director IIMA, to give welcome address.
On behalf of IIMA, let me welcome you to this unique conference. We hold many conferences in management and management-related topics directly towards the corporate management and capability enhancement of the corporate management domains. But thanks to Professor Ramohan, with his great effort and his interest in the area, and also thanks to Sanket Mahapatra working and leading right now the effort of Mishra Center of Finance, which has been a great support not only for this conference but for multiple activities happening in the finance research domain of IIMA Hyderabad. So I am thankful to the Mishra Center for not only sponsoring and supporting this conference with the full-fledged staff and facilities, etc., and so on, as well as the financials, but also many other conferences and works they have been doing in this aspect. Today's conference, I am not going to get into the detail as you have the three domains of that industry. The chairman of Bankruptcy Board, IBBI, himself is here. We have a chief economic advisor with us who will be able to highlight. It's a great opportunity, and also the Tata Group Chief Counsel is also here. So it's a great opportunity to have interaction with these three persons and listen to their views, what they have to say, and what is happening, or what are the issues they are addressing in trying to unlock the money which is stuck because of the various bankruptcy aspects or financial reconstruction that needs to be done in multiple companies, etc., and so on. It has been a wonderful journey. I think court came in 2016 or so. Of course, the initial court. As you progress further, you encounter the newer situations, have been evolving over a period of time, and it has addressed multiple company resolutions, or created multiple company resolutions, and continues to evolve. The good part of the IBBI setup is that it's not a static body. It has evolved as and when it encountered the problems, or it saw newer domains or newer areas which were not envisaged in the earlier aspects, and it has added and improvised on that as it has gone on. So today's deliberations will also give you an opportunity through your research and your viewpoints, what you have found in the field, to present those papers and present those cases, and also it will be a great opportunity for IBBI to learn from those cases, and if any of that research can be incorporated into as the IBBI moves forward in this progress, it will be a great help and it's great assistance to not only the companies which are facing the bankruptcy, or the creditors who are facing the loss, supposedly or whatever, are potential loss of money, but also for country and economy to move smoothly in future domain. As I said, we have three experts, so I thank their presence here, as they have been able to spare valuable time for this event at IIM Ahmedabad. IIM Ahmedabad is always an open platform, as already talked about by Ramon, that we are an open platform, open for discussion, all kinds of issues and problems of facing not only the management field, but the country's economy as a whole, because the foundation of this institute are founded, based not for creating the corporate managers, but for creating and addressing the management-related problems of the whole country as a whole, and that is the philosophy this institute was founded. This conference actually fulfills the role of reinforcing the basic philosophy on which we have been founded. Thank you very much. I will not take any more time of yours, as you can listen to the great experts today. Thank you.
Thank you, Bharat. Now we turn to Dr. Mishra, who doesn't need any he is an alumnus by IIMA, currently the Chief Economic Advisor to Government of India. So, welcome back. Please walk around the campus. You can see a lot of changes. I was really encouraged to visit the whole campus soon before it changes drastically. Please.
Respected Director, Professor Bharat Bhaskar, my colleague in the Government of India, Shri Ravi Mittal, Chairperson IBBI, Shri Siddharth Sharma, Group General Counsel, Tata Sons, Shri Piyush Mishra, Benefactor of the eponymous Mishra Center for Financial Markets and the Economy, Professors Ramon and Sanket Mahapatra, other professors, research scholars, students, guests, good morning to all of you. And I thank the Mishra Center and the professional organizers for their kind invitation for me to deliver the inaugural speech for the annual research workshop for insolvency and bankruptcy. Coming to IIMA is always a trip down memory lane for me. This is my first visit to the campus after becoming the Chief Economic Advisor. Previous attempts did not work out. I'm glad that this one did. Not only did this place contribute significantly to my learning journey, but it also bestowed me with some lifelong friendships. And for more reasons than one, I will always be indebted to this hallowed institution. Apart from the personal nostalgia, I am particularly enthusiastic about today's event since it provides the right juxtaposition of policy with academia, which, as much as I hate to admit, is sadly missing in the Indian context. There is often a gaping abyss between policy formulation and academic research in India, which needs to be addressed on an urgent basis. The intellectual energy of the academia should fuel the policy formulation, and the practical acumen of the policy maker should inform academic research if India has to devise an ambitious as well as an actionable strategy as we march towards Viksit Bharat at 2047. Let me now move on to the task that has been entrusted to me by Professor Bhaskar and the organizers of the event. Turning to the evolution of the insolvency and bankruptcy landscape in India, India's legal landscape concerning insolvency and bankruptcy has undergone a series of reforms since the 1980s. The key driver of these reforms was the challenge posed by fragmented laws that resulted in inefficient and costly resolution processes, thereby dampening the flow of investments in the country. The inception of the Board for Industrial and Financial Reconstruction, BIFR, and the SIP Industrial Companies Act of 1985 marked the country's initial foray into addressing industrial districts. However, BIFR's shortcomings, which allow defaulters to exploit legal loopholes, underscore the necessity for more robust measures. Subsequent reforms introduced special courts like the Debt Recovery Tribunals in 1993 and significant legislation such as the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, SARFAESI Act. Despite these efforts, the resolution process remained hampered by inefficiencies. Provisions within the Companies Act 1956 dealing with compromises, arrangements, and winding up proceedings also proved inadequate in facilitating effective resolution. The insufficiency of the fragmented insolvency framework was also evident within the banking sector, where the prevalence of non-performing assets has imposed significant constraints on credit availability and, in the process, stifling economic growth. The inability to effectively resolve non-performing assets not only weakened the financial health of the banking system, but also hindered the capacity to extend credit to productive sectors of the economy. Furthermore, the lack of a robust insolvency framework eroded investor confidence both domestically and internationally, casting doubts on security of investments and deterring much needed capital flows. The dearth of investor trust not only impeded the flow of domestic capital, but also acted as a deterrent for foreign investors, hampering the realization of the nation's broader economic development objectives. Thus, the imperative for legislative reforms culminating in the enactment of the Insolvency and Bankruptcy Code in 2016 was born out of a comprehensive review of the country's outdated insolvency laws and the failure to adequately respond to the evolving needs of a modern economy. The enactment of the code has led to the creation of an insolvency ecosystem that previously was non-existent. It has brought focus to the missing part of the business life cycle, which is revival, reconstruction, and recovery. The code put in place laws and institutions for a hitherto unaddressed segment of economic activity. It brought to light a segment of the economy that was lost from sight and gave us the means to deal with distressed assets. The code is an important reminder, if one was needed at all, of how legal institutions are vital to setting up guiding contours in a modern-day market economy. The code's overarching goal of timely resolution aimed at bolstering credit markets, fostering entrepreneurship, and enhancing ease of doing business are being met. By providing market-driven mechanisms for non-performing entities to exit and empowering entrepreneurs to revive viable and insolvent businesses, the IBC has sought to strike a balance among the interests of all stakeholders. The establishment of the Insolvency and Bankruptcy Board of India on October 1, 2016 further fortified the regulatory framework. The immediate effects of the code have been well documented. Let me highlight them briefly here. First, as of December 2023, 5,426 of the 7,325 insolvency processes initiated since the commencement of the code have completed their journey under the law. 56% of these companies have come out as functional companies. They continue to contribute to the economy as enterprises that productively use capital and labor. These companies have proven their economic and allocative efficiency in the economy and hence stood the test of the market. I will be remiss if I do not acknowledge the study done by Professor Ram Mohan and Gopal Krishnan of IIMA of this institute on the effectiveness of the resolution process published last year. I am personally grateful to them because we publish a monthly economic review in the Department of Economic Affairs. And we always look for research that validate the public policy making process. And it is good to get this kind of empirical validation of the landmark legislation and the process that was put in place in 2016. Second, companies in the manufacturing sector form the largest cohort against which insolvency has been initiated and also the largest set of companies that have been successfully dissolved or those that are slated for liquidation. Keeping aside the point of the financial health of these companies for a moment, one can see a sector where the forces of creative destruction are in full play. This is a sign of an economy that is active and dynamic. At the same time, the fact that manufacturing sector forms the largest cohort against which insolvency has been initiated is a prompt and reminder to policymakers to reflect on the factors that may be impinging on the solvency, economic viability, and competitiveness of the manufacturing sector. Third, about 6,319 crores has been brought back into the companies through avoidance transactions identified and reversed during the insolvency process. This figure may appear small in terms of the quantum given the economy's size, but again, its contribution is a fact that it strikes at many suspicious and fraudulent practices. It has brought the focus back to corporate governance and responsible business practices. 4. IBC is incentivizing debtors to settle defaults even before cases are admitted under the code. Over 27,500 applications for CIRP, Corporate Insolvency Resolution Process, with an underlying default of 9.74 lakh crores were withdrawn before admission. This shift in behavior has reshaped the narrative around NPAs and defaults. It's no longer just a bank's predicament, but it also has become a concern for the borrowers, as should rightly be so. As a result, borrowers now face the pressure, apprehension of repaying loans to banks. The Reserve Bank of India, in its report on trend and progress of banking in India 22-23, noted that amongst the multiple channels through which banks resolve their stressed assets, IBC remains the dominant mode of recovery with a share of 43% of the total amount recovered in 2022-23. Lastly, what is of particular note is the evolution of subordinate legislation brought out by IBBI. A clear hierarchy of regulatory instruments, regulations, guidelines, circulars, and facilitation letters have been put to use to enable the operationalization of the code. The regulator and regulations have been responsive to market stakeholders and are in alignment with the development of jurisprudence. IBC has evolved to become a regulator above par, and it is a benchmark for other institutions. Of course, it goes without saying that IBC is still in its early stages and the landscape continuously evolves as it must. However, the point that I would like to emphasize is that its transformative impact has already been felt, marking a significant departure from the shortcomings of the previous insolvency regime. As a strong positive signal to the emerging new entrepreneur, the resolution numbers have shown without ambiguity that there is life after insolvency. This is a signal contribution of the code that cannot be measured or quantified in numbers. This signal is of inestimable value for a young country with immense entrepreneurial energy. The impact it has on removing stigma associated with a failed venture is of tremendous social and economic significance. The way forward. Looking ahead, the efforts of the government and IBBI have been consistently directed towards refining the code and its associated regulations. The goal is to steadily force corporates to improve their standard of governance. Through initiatives such as issuing discussion papers, IBBI actively engages with stakeholders, including industry experts and the public, to shape insolvency regime. This proactive approach fosters transparency and inclusivity in the regulatory process by inviting constructive feedback and suggestions. By staying responsive to the evolving needs of India's insolvency landscape, these efforts ensure that regulations remain adaptive, and let me highlight a few examples in this context. Following the recommendations of the Amitabh Khan Committee, the board has now made necessary amendments that allow for project-wise insolvency in the real estate sector, which has put the onus on the developer to find means to repay the debt of insolvent projects, which was not the case earlier. and thereby enhancing the chances of settling debt and increasing recoveries for creditors. In a move to offer relief to home buyers, IBBI has also implemented substantial modifications to the liquidation process, prohibiting liquidators from selling housing units already allocated and occupied as a part of the liquidation proceedings. This amendment has instilled confidence among home buyers. Further, the government is also planning to establish a unified information technology infrastructure connecting diverse stakeholders within the corporate turnaround ecosystem, aiming to enhance the effectiveness of debt resolution processes. The interconnected network will incorporate entities such as the National Company Law Tribunal, IBBI, credit information providers, lenders, distressed businesses appearing in tribunals, insolvency professionals, National E-Governance Services Limited, etc. This initiative is poised to address information asymmetry among these agencies, facilitating better case monitoring and reducing delays. Upon implementation, this system is anticipated to streamline operations, consequently improving the ease of conducting insolvency-related activities for practitioners. The journey of this law has been proactive and dynamic. Significant expansion of the scope of the ecosystem has been made with the addition of the insolvency process for personal guarantors to corporates and non-bank financial institutions and the introduction of the pre-pack process. This expansion in the insolvency regime has been organic and is a measured response to market necessities. Amidst all these dynamic revisions and evolution of the code and the process, it may be useful to reflect on whether the regulator has been able to ensure that different levels of the judiciary understand the importance and implications of legislation such as the insolvency and bankruptcy regime and contribute positively to its evolution, its regulatory dimensions and economic efficiency while ensuring fairness for debtors and creditors. In general, and not just with respect to IBBI, it may be desirable for mechanisms to evolve for a regular dialogue between regulators and the judiciary, for the latter to understand the intent and substance of the regulation, and for the former to gauge the level of understanding in the judicial system of the purpose and underlying goals of legislation and rules framed thereunder. In conclusion, typically, a regulatory institution like IBBI is an extended arm of the government and is endowed with legislative, executive, and quasi-judicial powers and mandated to carry out the respective functions. In theory, these powers are enough for a regulator to carry out its mandate, but in practice, it is never sufficient. The establishment of an entire ecosystem up from its foundation and to put in place the building blocks requires more. A regulator is also positioned in a development role where it has to ensure that all stakeholders across the board learn and grow together. Conferences and workshops such as these provide an excellent opportunity for facilitating this mutual learning. In this spirit, I would like to leave you with about 7 questions, which I hope you may like, which you will delve into in the course of the 2-day workshop. First, how does the effectiveness of India's IBC regime compare with other countries, particularly with respect to the inclusion of all claims of all types of creditors in the resolution process? Has this come at the cost of financial creditors, or has it improved credit discipline among debtors? 2. What are the metrics and benchmarks by which the government can measure the success or effectiveness of the IBC regime and the regulator, IBBI? Third, how has insolvency law affected the choice between equity raising and debt financing for businesses as well as the choice of organizational structure? 4, how do we deepen the market for distressed assets and direct investments into the reconstruction of such distressed assets? 5, what are the behavioral impacts of IBC on corporate governance and credit flows? 6. What has been the impact of IBC on financial intermediaries? And lastly, what are the lessons that IBC has for other debt recovery channels? I understand that this workshop has gathered some of the best minds in the country on the insolvency landscape. I sincerely hope that you can learn from each other and in the process constructively contribute towards the government's continued efforts to strengthen the insolvency redressal system. I wish all of you a very productive engagement in the course of the next 2 days. And thank you once again for the invitation.
Thank you, Nagesh. We hope to perceive all of it one day. It's always a pleasure to hear Sri Chairperson David. The energy and passion which he brings in working of IBBI is it what takes to build an institution. IBBI represents the energy now.
Good morning, everyone. Professor Bhaskar, Director, Ahmedabad. Dr. Nageshwaran, Chief Economic Advisor, Government of India. Mr. Siddharth Sharma from Tata Sons. Mr. Ram Mohan and Sankar Mahapatraji and Piyush Mishra ji, friends. At the outset, I would like to thank Ahmedabad for starting this annual conference thing. We want to engage with researchers, with academicians, and we want to have a very healthy dialogue between IBBI or between the government and between the academic team. For this, we started and we had a conference in Ahmedabad last year. And I'm happy that that conference has provided a catalyst for Ahmedabad to start this annual conference. We had the second conference at IIM Bangalore, and we are having the third conference this July in ISB Hyderabad. So we are trying to deepen our relationship with the academic field. We take these conferences very seriously. In the last two conferences, for example, have helped us in formulation of some of our regulations. I can give 4 or 5 examples at least where these deliberations have helped us. Just before coming here, I was talking to Professor Ram Mohan, and he was telling us that he has received about 100 papers or 90 papers for this event. You know, I'm happy that 7 of these papers, 6 or 7 are by my officer. They are all here. You know, I feel very proud of it. And you know what we have done is, all your 30 papers that you will present in these 2 days, we have divided it among these officers. Now each of them will listen to each of your paper. And then tell us in our office as to what policy changes we can make in our regulations. So we take, we take these interactions very seriously. That is the first point I want to make. Just before coming here, Director of IIM Ahmedabad was telling me about the real estate issues that they are all facing. I agree that real estate is a very important field, and perhaps IBC has not done enough about the real estate issues. But let me tell you, one of the biggest resolutions in real estate in the world, the JPE case, has happened in India. It has been approved by NCLT last year, and it is at present pending before the NCLT, NCLT. Now last week NCLT passed an order giving 1 month for the Greater Noida and the RA to settle this issue among themselves. Otherwise, they said they'll pass a judicial order. So I expect I expect that in the next 2-3 months, this JP case would be resolved to the satisfaction. Now, in the IIM Bangalore conference, there was a presentation on the Chinese Evergrande case. I remember. Now, they were facing a lot of problems. There was an Insolvency conference last year in Tokyo, where President NCLT had gone and he was saying that the Chinese wanted to learn as to how India has resolved or is resolving the JP case. So it is not that we have not done anything about real estate cases, but yes, I think the expectations are too high, and perhaps we have, we need to do more. I want to talk about 3 things related to IBC. The first is about innovation. Now, as the Chief Economic Advisor was telling us about the achievements of IBC, about 9 lakh crores cases have been resolved even before admission. There have been direct and indirect benefits. But if we have to take IBC ahead, we need some innovations. Because one size fits all doesn't work in any field and doesn't work in IBC. We have, IBC has resolved the largest steel plant, which Tata Sons would be able to tell us. He would be able to tell us more about it. So through IBC, the largest steel plant has been resolved. Some very small MSMEs have been resolved. We have hospitals. We have today we even have what is called a news agency being resolved. We have Future Group, a service industry being resolved. So we have all kinds and all categories of companies which are getting resolved under IBC. And we have to understand that not everything can be done in one way. So you need innovations to cater to different kinds of companies. Now, so we from IBBI, we have done some innovations. As the Chief Economic Advisor was saying, we have done some innovations for real estate. We now want companies to become, or firms to become resolution professionals. Because big firms cannot be resolved by individuals, that is our view. So we want firms to become resolution professionals. This is one thing we have done. We have also permitted multiple plans. Because we have found that there are companies which are situated in more than one city or more than one state. Now, not very many resolution applicants are ready to take over the whole company situated in, let's say, one part in Gujarat, one part in UP, one part in Tamil Nadu. So 3 plans can perhaps come. Similarly, there are companies which deal with various kinds of activities, finance, manufacturing, and so on and so forth. Now, there is a company for which a resolution plan was invited, not much interest came. And then they divided it into 3 parts: pharma, finance, and others. So they have got 16 EOIs. So this is another thing that we are encouraging, that is multiple plans. So what I want to say, innovation is perhaps very necessary for taking IBC forward. And it is here that I need your help. I need you to study the innovations that are happening in other countries and give us solutions. We also try, but we sometimes we fail. So we would like research conferences like these to look at innovations happening in other countries, because insolvency, let's say in UK or in USA, Europe, or even Hong Kong and Singapore is older than our insolvency. So they have gone through this road that we are at present going, and perhaps we need to learn from them. So innovation, I think, is a very important thing in resolution, and perhaps we need to do something about innovation. The second thing that I want to talk about are delays in the IBC process. You know, wherever you go, when I talk to people, they tell me, IBC is a very good thing, but there are delays and there are delays, and we need to do something about the delays. Here I want to say two things. First, IBC prescribes a 14-day timeline for admission. Now, this is not an ordinary admission. What does admission entail? The admission in India entails taking over the company from the original promoters. This does not happen perhaps anywhere in the world. So admission is not a very simple thing that you just find something in the NCLT and the NCLT just admits. The promoter will try as much as he can to ensure that admission does not happen. So admission is not a very, doing it in 14 days is I should not say it, but it's very challenging and perhaps it's unreasonable. Similarly, we are trying to resolve the entire thing in 180 days. Now you are managers here or you are students of management. Have you ever heard a reorganization of a company outside IBC, forget IBC, being done in 180 days? How much does a reorganization of merger, acquisitions, reorganization of companies take in actual practice? Just think about it. What little I know, it takes 2 years, 3 years and so on and so forth, is what I have heard. The merger of Air India and Vistara, when was it announced? And when will it happen? Nothing to do with IBC. Take the case of a public sector unit. When the government announces that they'll come for they'll disinvest it or they'll come for an IPO, and the day they disinvest it, how much time does it take? We have a representative from Tata Sons. Now they are facing a problem with Reserve Bank. Now, how much time will they take to resolve it? So, we need to understand as to whether the 180 days that we have prescribed is reasonable. It is prescribed in the law, so I can't say it is unreasonable. But it is certainly challenging. So the second point that perhaps you can research on is to compare what happens outside IBC. In case of amalgamation, in case of mergers, in case of IPOs, in case of reorganization, and so on and so forth, and then compare it with what happens in IBC, and then judge whether 180 days is enough or not. One can also see as to what is happening in other countries. Are they able to resolve it in 180 days, or what was happening before IBC? And I'm not here to defend IBC. I'm not, trying to say that. But if we have to resolve a company in a proper way, then perhaps we need to put in more effort and perhaps spend more time. So this is the second area where I would really request help. You can tell us where our processes can be further reformed, can be further improved. You can tell us. But please look at how things are happening in other fields or in other areas. The third point that I wanted to talk is, again, came from the discussion that we were having before we started. We are all aspiring to be a 5 trillion economy in 2 years' time. I also hear that we are aspiring to be a 10 trillion economy by 2030 or something like that. What does this mean? Today, what what is our GDP? Today, our GDP is about 325 lakh crores. About, I will give very approximate figures. What are the loan outstanding or credit outstanding? The credit outstanding of, I believe, scheduled commercial banks is about, I believe, 175 lakh crores. And the credit outstanding of NBFCs, another 40-50 lakh crores. I mean, these figures are approximate, so you can Google it, but I am only, So the credit outstanding would be about 225 lakh crores. Let me give a ballpark figure. So, to support an economy of 325 lakh crores, you need a credit outstanding of 225 lakh crores. Now, please do a study of, please prepare a graph as to what was credit outstanding and what was the GDP in the last 20 years. There will be ups and downs like Nifty or Sensex does, but you will get a correlation between the two. For example, we all say that in 2008-9 or so, India had a very high growth, but India also had a very high credit growth. So just have a look at it. So now, if we want a GDP of, let's say, $5 trillion, or let's say 425 lakh crores, this credit growth also needs to increase from 225 lakh crores to whatever it comes to, slightly more than 300 lakh crores or so. It needs to come to that. If this credit growth does not increase GDP, it will be very difficult for GDP to increase. Now, to increase the credit growth by 75 lakh crores or 100 lakh crores, banks need capital of about 10 lakh crores. That is the again a ballpoint kind of thing. Now, from where will this 10 lakh crore come? In the next 2-3 years, that is when we want to become a 5 trillion economy, banks today are showing an operating profit, I believe, of about 1.5 to 2 lakh crores. Let's assume that the same growth happens. So, in 2 years' time, about 3 lakh crores or about something like that will come from the operating profit of SCBs or scheduled commercial banks. So, where will the next 5-6 lakh crores come? In India, we do not allow corporates to own banks. So, if Reliance or Tata or anyone wants to own bank, they can't. It's not allowed. So, where will this capital come from? One can say that there are financial companies which can contribute to capital. Yes, they will. I'm sure they will. But even then, there will be a large gap. So this gap, measures like IBC, SURFACE, DRTs, making them more efficient is very important if you want to become a 5 trillion, 10 trillion economy, because they will have to contribute to the capital of the bank. And if we are not able to make these measures effective, it will be very difficult for us to achieve our targets of GDP that we have set for ourselves. Now, what are these measures achieving as of now? The Chief Economic Advisor referred to an RBI report. So last year, these measures contributed to about 1.25 lakh crores. Not a small amount. And IBC out of this 1.25 lakh crores contributed to about 55,000 crores. So 55,000 crores was contributed by IBC as a direct recovery to creditors. And all these mechanisms contributed to about 1.25 lakh crores. Now this is mentioned in the RBI report, this is mentioned in the economic survey. But we have to improve this, we have to increase this. And our target should be to increase this to at least 2 lakh crores a year. So this is another item, another topic that I would like to request you to research on. To tell us as to how do we improve ourselves, not just IBC, but also SurfaceC, also the DRT mechanism, and also other mechanisms, so as to achieve this target. Because without achieving this target, it will be very difficult for us to grow. This is really the importance of these recovery mechanisms, including IBC. The last point, it was mentioned about the IIM study, which Professor Ram Mohan has done, which has showed as to how resolutions are helping the economy. Now these resolutions have also changed the behavior between the creditor and the debtor. So we have requested IIM Bangalore to do a study on the behavioral impact of IBC. And I hope that this study will come out in the next 4-5 months' time and will give us or provide us more inputs as to how to improve the IBC process. So I would like to thank IIM Ahmedabad for giving me this opportunity, inviting me here. I'm talking to you, and I also would like to thank all of you for coming on this Monday morning and hearing me. Thank you.
Thank you, sir. Now we have Siddharth Sharma, Group General Counsel at Associates. Siddharth is one of the youngest Group General Counsel at Associates, and directly reports to Group Chairperson. He has seen all our transactions, whether buying Air India, or buying doing store in India, or buying resource assets. He has seen it all.
Good morning, everyone. Professor Bhaskar, Dr. Nageshwaran, Mr. Mittal, Professor Ram Mohan, and Professor Mahapatra, other distinguished members of the faculty, participants for this who come from all over the country for this workshop, and students of this great institution. I'm very happy to be here. Last time I was here was as a student. Professor Ram Mohan and his colleagues had curated a course, I would say first of its kind, for in-house lawyers, the chief law officers who work with corporate houses. So I had come to attend that. And today also I must say that I am here as a student of law, and I don't claim any expertise. As you know, chief law officers are called general counsel. So they're supposed to be generalists, we are not experts. And but I'm very happy to be here because a forum like this offers you an opportunity to discuss not only what the law is, but what the law should be. Usually you end up solving everyday problem, doing transactions, but the purpose of a law, why this law is there, what it could do more, what it could achieve more, all those aspects you only get an opportunity to discuss, share your views on a platform like this. So I'm very happy and thank you for having me here. IBC, I am sure all of us will agree that is one of the most important and a landmark economic law reform of by far, definitely in the last decade. Why I say so? Because while we had the liberalization of early 90s and Indian economy took off, we had many laws. We got the new arbitration law, we got the competition law, but the Companies Act was modernized, was changed. The whole foreign exchange management law, FERA, we moved to FEMA. So all those reform laws were made, but one piece was missing in this whole jigsaw puzzle, and that was to address a reality of commercial life, and that is business failure and inability of firms to pay their debts. Dr. Mittal said that what role debt plays in the growth of the economy. To fund any economy, it's largely the debt that is funding the economy. Equity is always smaller. Equity has higher risk, but debt is what funds the economy. But debt has its own risk. You will not have all businesses which will be successful. So it has an inherent risk. So how do we address this scenario which emerges when a borrower is unable to discharge its debt? Now it has to be that borrower can be a borrower for several parties in the market, and therefore it has to be done in an orderly fashion. And that orderly resolution has to come about with the help of a law. So that piece was missing. Of course, we had other laws. We had the Sikh Industrial Companies Act, but they were not successful. We know, I don't want to go into the details of why they did not work, but they were not successful. And therefore, there was a need to have a new law, and IBC filled that gap. Now, another important aspect of IBC is that not only to address the debt resolution, it is also to recognize another very core principle of any economy, especially ours, where capital will always be scarce. So all economists will tell you that capital must move from inefficient allocation to efficient allocation. So if capital is stuck in a failing firm, it has to move to another firm or another venture where it can be utilized more efficiently. And therefore, value preservation and reallocation of capital is another core object of the IBC, which IBC seeks to achieve. I'll come in a moment on another objective which I respectfully, I don't agree with fully, that IBC is not a recovery legislation. There has been criticism around it that how much money IBC has recovered for the banks. IBC is not really a recovery legislation. I'll come to it a bit later. Now, these are the commercial realities. Now, one may say that we are in free market economy and free market forces will work themselves out, they will resolve these things. But free market is not absolutely free after all, and it has to be held in place by a system of laws. And that is why a legislation like IBC was needed. And I am sure we all will agree that we are happy that we have a law in place. Now, of course, it has its challenges. Now, in initial years, any law will have teething problems, but IBC has had its own challenges, the challenges that we face in working of this law. But one good thing that you would have noticed is that at least both the Parliament and IBBI, they have been very prompt in addressing those challenges through amendments. Arbitration law, the new arbitration law, what we call, based on New York Convention, was enacted in 1996. And the first major set of amendments came only in 2015. But IBC, if you see, we have amendments almost on annual basis. Whenever there is a problem, either because of a judicial decision or any other gap that is identified in the working of the law, at least there has been a prompt response to addressing that. And for that, we must congratulate IBBI, the entire team of Mr. Mittal, that they have been constantly looking at the problems, and there has been a dialogue. You have a forum where you can share ideas, share concerns and solutions, and they do get implemented. And after all, any reform is a continuous and a dynamic process. You can't legislate a law and then forget about it. So it has to be done on continuously, a regular basis. Now let me speak about two areas which have been a subject matter of debate and discussion. One is, I would say, it's a tricky issue, but that is of group insolvency. Now, IBC addresses resolution of individual borrowers. Firm A has failed to pay its debt, and therefore the creditors of Firm A will approach the IBC court, and the resolution starts. Now, there has been a discussion about creating a framework around group insolvency. As you know, group concept is a very now well entrenched mode of doing businesses. You have conglomerates, you have layers of subsidiaries, so enterprises do work with different corporate structures, and group is one of them. You have multi-purpose or special purpose vehicles, entities that you create to do a particular business, and therefore what happens if one of the members of the group has defaulted? What if other members of the group have also defaulted? Whether you should consolidate all the members of the group in one proceeding? Can you consolidate all assets of all those entities and resolve them together? So these are very interesting questions which are being debated. We already have a report of the working group. I would just say that we have to be careful in this area in a couple of things. Now, take for instance the whole concept of what is a group. Now, if you look at RBI regulations, RBI defines group very broadly, but it has a specific context. You have core investment companies, and therefore core investment companies are recognized by RBI as entities which would invest only in group entities. Now, for that, RBI has defined group, which is very broad. Competition law has its own definition of group, because their competition law is looking at antitrust behavior, and it sees the economic might of a collective of enterprises, and therefore it defines group in a particular way. FDI policy has its own definition of group. So the key will be how do we define group for IBC purposes. Parent subsidiaries, more or less, it is, I think it is no brainer. You can definitely establish the relationship of a group. But an entity and an associate entity, where that entity only has 20% stake, can you combine the two as we call them group entities? Second, while addressing group insolvency, we cannot have a straight jacket formula. One size fits all principle will not apply here, and therefore it has to be calibrated. I said we have to be careful. See, for example, that suppose we are a parent company, we have a subsidiary. Now, subsidiary has gone into liquidation, or has defaulted on its debt. That has gone into CIRP process under IBC. Now, if you were to bring the parent entity also into the fold, then it can create complications. What if there are other shareholders which are sitting in the parent entity? Now, those shareholders did not sign up to the risk of the subsidiary. I have negotiated loan documents where we don't, even as a parent entity, we don't give the comfort or the guarantee to the lender. We negotiate no recourse lending. We also have provisions where we say that there will be no cross default provisions. If you lend to one group entity, just because that entity has defaulted, you can't say that there is default under my loan agreement with you. So these are again commercial realities, and therefore before we club everybody under one roof, we have to be careful of the complications and the genuine legitimate transactions that are happening in the market and how it can disturb the balance. The second aspect of group insolvency is, of course, the long-standing principle of limited liability and separateness of legal entities. I mean, this is the core company law principle on which entire world works, that every legal entity is a separate entity. You can't club the two, you can't combine the liability of one entity with another. And therefore, the passing on the risk of one entity to another cannot be done as a matter of course. Of course, if a group structure is being used as a device, as a sham to defraud, then that is the smell test that you apply. And for that you already have answers in conventional corporate law principle, like lifting of corporate veil, and which courts do apply. So what we have seen in the few IBC cases, for instance, Videocon case, where courts saw the dependency or interdependency of the group entity so much, they went for substantive consolidation of the IBC or the resolution process, where you combine all the assets, you brought together all the creditors in one group and said that you resolve together. But there can also be, for ease of administration, combination of or combining the proceedings. So say multiple entities within a group are undergoing CIRP, you can always say that only one NCLT will look at all those proceedings in one go, so that there are no inconsistencies. That is a fair ask, because that is more like a procedural consolidation, and that is for ease of administration of the CIRP process. I will leave this topic here because it is under discussion and I'm sure it will evolve in the coming days. The second issue that I would like to touch upon is that all of you must have heard, this was the phrase used by the Supreme Court, the clean slate principle. Now, clean slate principle is why it is relevant. See, I always feel that the IPC process is M&A in a controlled way. Two parties can negotiate an M&A transaction. It is bilateral. You agree on certain things, you agree on certain liabilities, you apportion the risk, and you go for the deal. But IPC is an M&A with the supervision of a judicial body within the framework of a legislation. That is the difference. But ultimately, it is a transaction. CIRP or the resolution process is nothing but a contract. Firm A has defaulted on its debt. The resolution professional takes control, and then an information memorandum is prepared and resolution applications are invited. Somebody in the market looks at this entity and comes up with a resolution application, which is a proposal. What in conventional contract law principle will say offer. So there is an invitation to offer, the resolution applicant makes an offer. That gets approved by the COC. Now, committee of creditors, they apply their commercial wisdom and they either approve a plan or reject a plan. While approving, they can even negotiate with the applicant. That can you do a bit more? Can you give a bit more for the operational creditors? Can you give a bit more for the employees? And a plan is finalized. Once a plan is finalized, then you have the stamp of a judicial body. Now, judicial body doesn't sit in appeal over the commercial wisdom of the COC. Judicial body is there to basically to satisfy its conscience that this plan is not a sham. It complies with the laws. Now, once the judicial body has approved it, that plan should become sacrosanct. If that plan is an open-ended plan, if even after resolution, even after approval of the plan, if the applicant is saddled with claims, then it strikes at the very core of principle of contracting, which is that when I do a deal, I apportion the risk. I decide how much liability I am taking. Consideration is certain. Now, in a contract, when consideration is not certain, then you can't call it a contract. Then it becomes a moving target. Now, think from a resolution applicant's perspective. If he doesn't get a clean slate, even after approving, getting the plan approved and implementing, if claims keep on coming, then where will it end? And resolution applicants then will be discouraged from coming up with resolution plans. As they say, no deal is better than a bad deal. And therefore, we have to be careful and we have to ensure that the legislative framework, judicial interpretation, everything supports and sustains this clean slate principle. Supreme Court has emphasized it. IBC and as a law and both IBBI, they have been very prompt in addressing whenever this principle has gone off course. So when we saw that government dues were being claimed even after a plan was approved, IBC section 31 was amended to say that a resolution plan once approved will be binding on everybody, including government, state governments, for their statutory dues. So the act has been amended. Clean slate, now I don't mean only the civil liability sense, but clean slate in every sense. Now I was involved in one of the first IBC cases, one of the biggest, when Tata Steel acquired Bhushan Steel. And after everything was down and dusted, we realized that we are being summoned as company in ED proceedings, in SFIO proceedings. Now it is also a reputational issue that why, as for our group, we should be involved in a criminal case. And therefore we approached Delhi High Court for quashing of those cases. But in the meantime, and this is again, I will go back to the first point, that how this law had been so nimble-footed, so agile in responding to the needs, that IBC was amended and 32A was added to give immunity to the new management. And therefore today, only last week, Bombay High Court has come out with a judgment again clarifying that Enforcement Directorate cannot attach properties after a resolution plan has been approved. Now all this is nothing but recognition of the clean slate principle. More or less it is settled, but once in a while I was talking to Mr. Mittal and Dr. Nageshwan in the morning before we came here, that how some of the Supreme Court judgments are bringing it back. And many of you would have read about this case, Rainbow Papers, where Supreme Court has held that a statutory due under state taxation law can be treated on par with secured financial creditors. Why? Because you would see, and this provision is there in many state laws, taxation laws, that when taxes are due, the tax department has a charge on your property. That is the charge which statute creates by default. Now this provision in the taxing statute was read by the Supreme Court to say that it overrides the IBC waterfall principle under section 53, which says that government dues are lower in priority than other financial creditors, secured employees and unsecured creditors. Now Supreme Court took this view. Unfortunately, in review it was not corrected. But again, it is heartening to know that an amendment is being considered to fix this problem. I have often wondered that why this is happening. And this will not happen if we recognize the core principle of IBC. What happens is that, and this IBC courts also have to recognize, they are not court of equity when they are deciding IBC cases. The urge to do complete justice, to ensure equality of outcome, that is not possible. In IBC proceedings, somebody will be a loser. A resolution applicant will never come up and say that I will satisfy all the debt. If you start ensuring absolute recovery for everybody, then we will not have a resolution. And that is why Supreme Court in Swiss Ribbon said that the purpose of IBC is not a recovery legislation. IBC is a legislation to ensure revival and continuation of the corporate debtor by protecting it from a corporate death by liquidation. We forget that when a resolution applicant is in front of us, we think that that person should satisfy all the debt because you see a resolution inside. We forget that if there is no resolution, what is the alternative? Alternative is liquidation. There is no other alternative in IBC. And therefore, liquidation destroys value. You can destroy a steel plant. You can say that, okay, liquidate the steel company. But do we know how much time does it take to set up a greenfield steel plant? And therefore, there is always a value in continuing an entity as a going concern. the value that we will derive from a going concern in longer term, that entity can service much more, many more loans in the future. That entity, if it continues as a going concern, can generate much more revenue for the exchequer. It can generate much more employment. But if you kill it, if you go for the alternative, then everything is gone. Everything is gone. And therefore it will take time to reconstruct. And that is the purpose of IBC resolution. IBC is not a recovery legislation. The object clause of the IBC says that maximization of value. So I shouldn't say that at any value you should just go for resolution. It does talk of maximization of value. But the preceding words are also very instructive. It says in a time-bound manner. And therefore, while it should not be done hurriedly, but we have to recognize that time is of essence. Let me just end by reading out a passage from a very interesting book that many of you would have read, Too Big to Fail, which was written describing what went behind the scenes when the financial crisis of 2008 happened. And there is a passage on what happened in court when Lehman Brothers, they filed for bankruptcy. And Lehman Brothers filed for bankruptcy, and the bankruptcy court in New York was presented with a deal in which Barclays was paying $1.75 billion for Lehman's North American operations. The plan was opposed vehemently by creditors and by many other investors who questioned whether the price that Barclays was paying was good enough. And after a marathon hearing, the presiding judge, in a midnight hearing, he pronounced the order, and the mood in the court was very somber. And he said, he approved the deal. He approved the deal. And he said that I am approving it not because it is the best available transaction. I am approving it because it's the only available transaction. And therefore we have to recognize that resolution is important. If you keep thinking that no, there will be another resolution applicant. If we keep continuing the legal process, there will be no end to it. In one CIRP case, NCLAT, I think it was one of the telecom cases, NCLAT said that CIRP cannot be used to wriggle out of government dues. You can't offer peanuts in the form of resolution. I disagree with this approach. If the application was a sham, it was a device, it was a fraud, please go after it. But I am saying the approach to a CIRP that you will get peanuts, you may get peanuts, I don't think that's the right approach. Because if the company goes into liquidation, you may not even get peanuts. That fact, that reality we have to recognize. Insolvency is the harsh reality of business world. And that is why this core principle of IBC has to be preserved. If it requires amendments on annual basis, we must do it. Because otherwise this reform will not sustain. It's very important that core principles of IBC are maintained. I agree with Mr. Mittal that the delay can't be attributed to the law, and that is a problem that plagues our entire judicial system. Think of it, NCLT and NCLAT. That's the core that administers the IBC. NCLAT, I say, is the most important commercial court in the country today. It has three most important corporate jurisdictions: Companies Act, Competition Law, and IBC. And therefore this court, with limited infrastructure, is administering three most important laws in the country. We have infrastructure problem, we have issues with appointments of NCLT members. In Chandigarh, I was told that there are 2 benches of NCLT, but there is only 1 courtroom. So they are alternating first half and second half. Now, obviously, so there are many problems. I don't think the delay debate should take over the other core debates around IBC, which I am sure this gathering will discuss in the course of next today and tomorrow. Thank you very, very much again for having me.
And this is a closure. Thank you all. Thank you, Siddharth. The planned and appropriate conversation. Final act is giving a memento. I would request my colleagues to give mementos to our guests. Mr. Balagopan, would you please give to Dr. Mary? Second to Chairperson IBBI. Third to Siddharth. Thank you all. We'll break for tea. We'll come back at 11:30.